The Fourth Amendment recognizes the sanctity of the home by drawing a firm line at the door. The government cannot cross that line without a warrant unless there is consent or exigent circumstances. Here there was neither. Respondent's warrantless seizure of petitioner from his home and their subsequent seizures of his lawfully possessed guns from his bedroom and garage violated the Fourth Amendment. The First Circuit tried to get around the warrant requirement by creating a new exception based on Katie. But Katie involved a standardized search of a car in police custody. It doesn't grant a license for intruding the home. Quite the opposite. Nearly every page of the court's decision relies on the constitutional differences between cars and houses. Respondents in the United States take a different tack. They claim that the warrant requirement isn't even implicated when officers act for non-investigatory reasons. But in case after case, the court has consistently applied the warrant requirement to homes, regardless of the government's purpose, including when public health or safety is at stake.
He can't come inside without a warrant. Well, unless you invite him in.
He's not a vampire, idiot. Plus, it's daytime.
If invited in, law enforcement can enter your home without a warrant. Once inside, under the doctrine of plain view, anything illegal, say a truckload of cocaine in the kitchen, can be lawfully seized as evidence. They can also enter a private residence under any number of exigent circumstances, like providing emergency assistance to an occupant, say if they heard someone screaming.
Nothing. Good morning.
No, sir. Good day. I insist that you leave immediately, as you have entered this residence unlawfully.
Yeah, you want to jump in here, Yoda's dad?
I invited him in.
What house?
And once you do that, we are in. Not unlike vampires.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Fourth Amendment, Constitution of the United States. It was December 21st, 1911, in Kansas City, Missouri, at the train station, as a matter of fact, when a man by the name of Fremont Weeks, it's a great name, was arrested by the federal police there. The reason he was arrested is that he had been accused of using the mail, the United States Postal Service, to send lottery tickets to people who were gambling, because lotteries, up until recently, were considered gambling and were thus illegal. And Fremont Weeks was cheating the system by sending lottery tickets through the mail. He was arrested, subsequently convicted, and sentenced to jail. Now, the problem with the whole thing was that the evidence against Mr. Weeks had been found in his home, in his locked home. The police had no warrant to go into his home. However, a neighbor, who knows what that relationship was like, said to the police, hey, his key to his house is right here, and showed him where the key was. They took the key, went in, found the evidence that said that Mr. Weeks was in fact defrauding people by using the mail to send lottery tickets, and they took it to the local U.S. Marshals, because this is a federal crime, for which they just happened to find evidence by going into his home with a key that the neighbor provided. The marshals looked at this and went, you can't do that. That's against the Fourth Amendment. No, that's what you would expect the United States Marshals to say. It's not what they said. What they in fact said was, got anything else? And so along with the other police, the U.S. Marshals went back to the person's house, re-entered the home, found more evidence, and decided to arrest Mr. Weeks, for which he was subsequently convicted. Now, you need to understand something here. The evidence is pretty firm. I mean, Mr. Weeks was absolutely guilty of using the mail service to sell lottery tickets, which, again, at that time was a crime. You couldn't do that. I don't know if it still is or not. I know the state can sell lottery tickets, but I don't know if they can use the mail or not. Who knows? It's a gray, fuzzy area now. But in 1911, it wasn't so gray or fuzzy, and Mr. Weeks was in a lot of trouble. But his lawyer looked at this and went, wait a sec. Where's your warrant? You can't just go into somebody's house, find evidence of a crime and go, well, there you go. And then turn around and hand it to the feds. You had no warrant. You had no right to give the initial evidence to the U.S. Marshal. You had no warrant for the second search with the U.S. Marshals. And ultimately, the Supreme Court ruled, you had no warrant, sorry. The conviction was overturned, the evidence was thrown out. They did not, however, in this ruling, they did not incorporate the Fourth Amendment against the states. Corporation was still kind of a new idea at that point, still hadn't reached the Fourth Amendment yet. And so eventually, through this and another case, you will end up with what the Supreme Court, in the words of Felix Frankfurter, will call the silver platter doctrine. The silver platter doctrine is an exception for evidence seized by state officers in searches that did not meet Fourth Amendment standards. In other words, they didn't have a warrant. The evidence is usable or was usable in federal trials when it was handed by the state to federal officers, quote, on a silver platter. Those are Justice Frankfurter's actual words. Now, let that kind of marinate for just a moment or two, if you will, please. Essentially, from 1911 until later, 1961, so for 40 years, my math isn't that good, you had a situation where the police could go in and search your home without a warrant, take whatever evidence they found, give it to the feds, and the feds could then prosecute you using evidence that they had not obtained with a search warrant, gain a conviction, send you to prison. So what do you think happened? What do you think happened for 50 years? Do you think local police departments said to themselves, well, this is a complete violation of the Fourth Amendment. It certainly isn't what the founders intended, the framers intended. It certainly doesn't hold water to us. Do you think the feds did that? Or do you think they went to local cafes and coffee houses and restaurants and sat down in smoky back rooms and went, hey, if you were to search that guy's house and find something and brought it to us on a silver platter, we could make the world a better place. Which of those two scenarios do you think happened? Extensively. In 1961, the Supreme Court finally got around to re-looking at the silver platter doctrine and saying to themselves, yeah, the problem is, and I'm going to say this, the problem is that the zealotry with which the government is pursuing convictions and crimes, and now they're encouraging state officials to conduct warrantless searches, is problematic. And so they actually ended up in 1961 reversing the silver platter doctrine, making it so that essentially incorporating the Fourth Amendment, saying, no, the states need to have this too. So you got to have a warrant to go into somebody's house. You can't just wander in and find stuff with the neighbor's keys. You can't just do that. And so we come into the future then to more modern times when Mr. and Mrs. Caniglia were having a bit of a marital spat. Now, I get the impression they're kind of an older couple. They've been around for a while. Mr. Caniglia does not like Mrs. Caniglia's brother. And one day, over the breakfast table, he made a point of saying he did not want to use the same coffee cup that her brother had used because he, quote, might catch a case of dishonesty, unquote. Mrs. Caniglia did not like the joke, and an argument ensued. We've all been there. And the argument got heated between Mr. and Mrs. Caniglia. And eventually Mr. Caniglia went to the bedroom, came back with his loaded firearm, put it on the table and said, "Here, just shoot me and put me out of my misery." Which again, Mrs. Caniglia did not find funny at all. And he got frustrated and left the house. She got frustrated and left the house. He got frustrated. She got frustrated. They both left the house at certain points. And eventually, Mrs. Caniglia, after the argument reignited in the afternoon, left the house and stayed in a hotel overnight. Next morning, feeling perhaps somewhat remorseful of this marital spat, she called the house and got no answer. She was immediately concerned. Instead of going home to find out what was going on, she called the local police and asked them to check on her husband and expressed her concern. The police went to the house. Amazingly enough, they found Mr. Caniglia on the back porch, just as calm as could be, no problems. He was lucid, he was fine, there was no problem. They asked him how he was doing. He said, "I'm fine." They said, "Are you sure? Because your wife's really concerned." He said, "Well," he volunteered to them. They did not ask him. He volunteered to them that, "Look, I'm not going to kill myself. What do you, she thinks I'm going to kill I'm not going to kill myself. I'm not suicidal." He volunteered that information, which immediately caused the police to go, "Well, maybe you should go get checked out. Maybe you should go to a psychological hospital just to make sure." He said, "No, if I do that, you'll seize my firearms, my lawfully owned, completely paid for firearms." The police said, "No, we won't." Eventually, Mr. Caniglia agreed to go to the psychological hospital, and so you know what happened, right? The police seized his guns. They lied to him. They also lied to Mrs. Caniglia. They told her the same thing. They told her, "We're not going to take his guns. We don't always worry about it. He's fine. He just needs to go to the hospital, get checked out. We'd feel better if he did. We won't take anything." Which, of course, they did. So, I don't know how else to say this. The police involved in this case lied. They were not truthful. They prevaricated. They fudged. They claimed something that was not true. And in the process of this, well, Mr. Caniglia's guns end up being seized. Now, the question is, when you go back to the Fourth Amendment, of course, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Mr. Caniglia brings a lawsuit claiming that this was an unlawful search and seizure because they basically seized him by convincing him to go get a psychological evaluation, but they also seized his guns after telling him that they would not. They did not have a warrant. They had no reasonable reason to do any of this stuff, and he felt that it had been violated. His Fourth Amendment rights had been violated. He filed suit in the First Circuit Court of the United States, which ruled, oddly enough, the First Circuit Court upheld the seizures as, quote, reasonable. They did so under the community caretaking exception, which comes from a case known as Cady, C-A-D-Y, which you heard the attorney talking about there, which deals exclusively with automobiles which have been removed from the road for public safety and subsequently searched. That's all it dealt with. But now the First Circuit Court took Cady and applied the community caretaking exception to homes, even though they actually wrote in their ruling the doctrine's reach outside of the motor vehicle context is ill-defined. They admitted that they had no definition for this, but they did it anyway. The decision extended the reach of the exception into private homes, ruling that the police, quote, did not exceed the proper province of their community caretaking responsibilities. Now, keep in mind a couple of things here. The police entered the house, having apparently been asked to do so by Mrs. Caniglia. They were doing a welfare check. They told Mr. Caniglia that if he agreed voluntarily to go get a psychological eval, they would not seize his weapons. I can't emphasize this enough because it plays back into the whole silver platter problem, which is the police lied. They lied. And for whatever reason, we don't seem to want to focus on that. But the problem is when you have something like a silver platter doctrine, when you have something like a caretaker exemption, human nature is going to take over, folks. Just like for 40 years, police, law enforcement were meeting together and collaborating to catch suspects that they wanted caught by bypassing the federal Fourth Amendment for the states. The police were using less than honesty here to seize Mr. Caniglia's guns. And he did not like that. The Supreme Court heard this case last week as we sit here at this recording. And there is a great deal of concern about this case because, again, it hasn't been resolved yet. The Supreme Court agreed to hear it because, in essence, the First Circuit Court has decided that the community caretaking, which initially applied just to cars, now applies to anything. That police can simply enter your home under the doctrine of community caretaking if they suspect a health or safety problem, which should kind of ring your bell right now because of the pandemic. Police can just enter my home because maybe there's a health or safety problem here. The administration, the Biden administration, has submitted what is called an amicus brief. An amicus brief is submitted to the Supreme Court by a party that is not directly involved in the case. So the federal government, not directly involved in this case. However, an amicus brief, friend of the court brief, gives the administration's position on the case for consideration by the Supreme Court. The brief wrote, the administration argues that the, quote, ultimate touchstone of the Fourth Amendment is its reasonableness. Warrants should not, quote unquote, be presumptively required when a government official's action is objectively grounded in a non-investigatory public interest, such as health or safety. It is the official position of the United States government right now that a warrant is not needed to enter a home, for the law enforcement to enter a home, if it is objectively grounded, whatever that means, in a non-investigatory public interest such as health or safety. We suspect something's not good here. We're going to go in and see what's going on. Needless to say, this has generated a great deal of response. The American Civil Liberties Union filed their amicus brief saying there is no doctrinal support for extending the community caretaking doctrine beyond inventory searches of automobiles. Katie and its progeny begin and end with standardized searches of vehicles under police control. But of course, the First Circuit Court, though ill-defined, has said, no, it's fine. Go on into a home. We don't care. Why would that bother us? Right? The Cato Institute has also added their amicus brief. When every interaction with police or request for help can become an invitation for police to invade the home, the willingness of individuals to seek assistance when it's most needed will suffer. In other words, people are going to stop calling the police for when they actually need them if every time we call the police, they're poking around looking for evidence of crimes, which they will then take on a silver platter, thanks to the First Circuit Court, and go, well, no, this is just fine with us. The Justice Institute said expanding the community caretaking exemption to private homes to, quote, allow warrantless entries into people's homes on a whim would invoke the arbitrary, looming threat of general writs that so incited the framers and would undermine the right of the people to be secure in their homes. It's absolutely horrifying that this ideology that underpinned the so-called silver platter doctrine could literally be returning here now. Police being allowed to enter your home under basically any context that's non-investigatory, deciding that they find something, and then using that evidence as now admissible is a little frightening. It should be, right? My wife and I were actually having a discussion about Facebook Messenger the other day, and the fact that she had someone that she was familiar with who had been contacted by law enforcement because of something that she had said in a private Facebook message. You know, the little messenger thing, not Facebook itself. They didn't post on Facebook, whatever it was she said. She sent it in a messenger to another person. And of course, Facebook objected to this and put the information on a silver platter, and she was investigated for it. If the First Circuit Court position holds, are we doomed to see more of that in the future, more of that kind of thing in the future, where they don't need a warrant anymore? Any non-investigatory, reasonable search, according to the the First Circuit Court, becomes an excuse to enter your home. And as the ACLU said in their brief, there are some jurisdictions where the community caretaking exception has extended to homes. And in those jurisdictions, everything from loud music to leaky pipes have been used to justify warrantless invasions of the home, unquote. Kind of makes you wonder, doesn't it? We've watched as the government tried, I mean, this was the whole point of the Fourth Amendment, was this concern about the government's use of its power to essentially break into your house and steal evidence, whatever that evidence might be, of your criminal activity and use it against you. Remember that there is a general idea that most Americans violate multiple laws every day because we don't even know what they are anymore. And now the government is arguing again, the same government that once upon a time we restrained from doing these sorts of things, is now arguing again that they should be allowed to once again do those same sorts of things. The Supreme Court heard the case, as I said, on March 24th, and we will keep an eye on whether or not your loud music and leaky pipes will become justification, as the Biden administration believes it should be, for law enforcement to enter your home. Because it might be health or safety. We don't know that it is, but it might be. By golly, you might be doing something criminal, and if you are, we should know about that.